Hi, this is Jack Meligan, your Medicare problem solver for the Plaintiff's MSA and Lien solution. Today's video, the first biggest mistake that even top trial lawyers make about liability MSAs. And here it is. The first biggest mistake made when it comes to liability MSAs is thinking that since MSAs aren't required by law in liability cases, that's the end of it. While it's absolutely true that there is no law requiring a Medicare set-aside account in either a workers' comp or a liability case, that's right, not required in either, that misses the bigger point. And the bigger point is that the law since 1980, when Congress passed the Medicare secondary payer provisions, is that Medicare is secondary to all forms of insurance, whether liability, self-insured, or no fault. So Medicare is precluded from paying your client's medical bills for accident or incident treatments once Medicare discovers that your client has had a settlement. So how does that happen? How does Medicare discover your client's settlement? There are actually at least two ways that can happen. First, defendants are legally responsible for determining whether your client is entitled to benefits under the Medicare program on any basis. And if eligibility is determined, defendants are to report the settlement to CMS through the Coordination of Benefits Contractor, or COBC, on the date of settlement or on the date of court approval, and it's subject to a $1,000 per day fine for every day that report is late. Section 111 of Medicare, Medicaid, and SHIP Extension Act of 2007 added mandatory reporting of settlements for Medicare beneficiaries. At last count, there are at least 196 data points that go into this Section 111 report to Medicare, and 3 are critically important to your client. The date of settlement, the total payment obligation to claimant, also known as TPOC or TPOC, which is the total settlement amount, and the ICD-9 or ICD-10 codes that identify the injuries or conditions that are being settled. Medicare takes this reported information and places it into your client's common working file. And then in the future, when your client's treating doctors send bills to Medicare and those bills are matched to injuries or conditions that were part of your client's settlement, Medicare is supposed to deny payment, leaving your client to pay. A second way Medicare can discover your client's settlement is if your client is not Medicare eligible at the date of settlement, meaning they don't have their Medicare card in hand, and therefore the defendant does not have to report the settlement. Medicare can still discover that your client has had a settlement when down the road your client applies for Social Security disability or retirement benefits and then gets their Medicare card and then self-reports. On or just about before receiving their Medicare card, your client may receive a very intimidating questionnaire that is printed entirely in red ink. The red letter asks your client, are you receiving treatment for an injury or an illness which another party could be held liable or is covered under automobile no-fault insurance? When your client answers yes and turns the page, then the real fun begins, as the red letter then asks for the name and address of their attorney. That's you. So whether the defendants report your client's settlement to Medicare or the client self-reports sometime later after becoming Medicare eligible, the effect can be the same. Medicare is supposed to deny payment of bills related to the injuries or conditions that are the subject of the settlement. If your client receives a letter from Medicare denying payment of their bills, and if they have run out of money from their settlement in the interim, what happens then? Well, you as their attorney can probably expect their call and a plea for help or blame for the problem. Don't let this happen to you. It can all be solved by using a voluntary liability MSA up front so that your client has put aside the minimum amount of money necessary to pay future settlement-related Medicare bills. When that amount is exhausted, Medicare by law covers your client for all accident-related Medicare allowable expenses forever. Outsource your Medicare and MSA headaches to the experts at Plaintiff's MSA and Lien Solution, and avoid having unhappy clients that end up having major problems with unpaid Medicare bills in the future and then putting the blame on you. Let us take the liability target off your back and unchain you and your staff to do other, more productive and less risky work than wrestling with Medicare issues. Help is just a phone call away. This has been Jack Meligan, your Medicare problem solver for the Plaintiff's MSA and Lien Solution.